SJC-12098, Stoneham Retirement Board, v. Contributory Retirement Appeal Board, and another.
Mr. Martland, good morning.
Good morning, Your Honors. May it please the Court, Douglas Martland, Assistant Attorney General for the Contributory Retirement Appeal Board. Chapter 32 doesn't allow Stoneham to use a provision that deals with letting part-time employees into membership to knock that same membership, to knock that person who is already a member out.
Can I ask you a question? It seems to me that the Stoneham Retirement Board did two things. They said for 9 weeks she was, I guess, eligible to be a member in service, but for the rest of the time she was not.
That is
Them at the same time. It wasn't like they did one thing a long time ago and then they just did something else years later. I mean, they made that decision at the same time. It was at the most recent board, right? I mean, so why isn't that a determination of eligibility as to both aspects of it? An initial determination of eligibility. Why isn't that simultaneous decision as to both prongs? An initial determination as to eligibility for membership.
Your Honor, we agree that Stoneham had the authority to make an initial determination as to whether Ms. DeFelice was eligible for membership in the retirement system. But once they made that determination that she was eligible, and after she worked more than 30 hours for a period of 7 days, they had a very low threshold for eligibility here. After she met that standard, and all the parties here agree that she did, the reasons that they can terminate her are set forth in Section 31A1.
What is the... finish your answer, I apologize.
That was the end. Go ahead, Your Honor.
Oh, could you just give us the sort of practical implication of this? By having this 7-day period in 2001?
Yes.
And here we are in 2016.
Yes.
What are the implications of that?
The implications, Your Honor, is that the legislature here gave...
But what does she get? She's a member of, she's a member of the system, so that means when she retires, she has health care for all her...
Your Honor, she would be entitled to buy back in her service. This was a late application for membership, so she had accrued some service. She was attempting to buy it back. She would have to make her contributions with interest, and then depending on the overall amount of service that she had, she would be entitled to a pension from the town.
And she buys for the service even though after that week, or actually it was 4-month period or 3-month period, she doesn't qualify under Stoneham's system at all. She can still buy it back. Is that what you're saying?
Your Honor, the statute is very clear, Section 4.1, that once you are a member in service, you are entitled to credible service for all of your service for the governmental unit.
All right.
And so the critical piece here is that Stoneham set a very low threshold for eligibility, and that she became a member by meeting that very low threshold.
But I think, at least my question, and I think it might be Justice Botsford's as well, is, okay, put aside the time that she had worked in a school before she worked at Stoneham. Mm-hmm. If she works only 10 hours per week for 10 years after she had become a member, does she get, how much credit, what is the creditable service you get for part-time work?
She would get proportional credit for that 10 hours of work.
Proportional being basically 1/4.
Yes.
So basically, it would not be that she is treated as having part-time work is treated the same as full-time work. It would simply be that part-time work would be treated proportionally.
Right.
And she would get credit for whatever part-time work she did, having been at one point in time a full-time employee.
Yes.
But if she had never been a full-time employee, then she would not get any credit for that part-time work.
If she had never been a member in service, and there is a distinction here because Stoneham's very low threshold for eligibility is 30 hours for a period of 7 days. So that's not full-time work. And we agree that 32D gives Stoneham the authority over that initial membership But it's once you're a member, you're entitled to credible service for
Why
all
is
of
that, though? 32, Section 3, why is it limited to initial eligibility and not eligibility at any point in time, just based on the plain language of the statute?
4 reasons, Your Honor. Number one, I'd point you to the 2 examples in 32D that follow. One relates to a vote by the board where an employee makes less than $200 a year. A vote is very clearly an initial eligibility determination. The same thing, the second example relates to a teacher in the Boston school system who works for a year. At the end of the year, the teacher is deemed to be a member in service of the school system. Both of those are very clear examples of an initial eligibility determination with no continuing monitoring by the board. We already have a statute that deals with that. Section 31A1 sets forth the circumstances where a person could be removed as a member in service from the local retirement system.
Is there legislative history, one way or the other, about how to construe these statutory provisions in relationship with each other?
Not that I'm aware of, Your Honor, but I would point you certainly that we should avoid interpreting these statutes to create a conflict.
No, I understand that. I'm just saying that it looks like these 2 statutes have been around for quite some time. I mean, I'm sorry, these 2 statutory provisions have been around for quite some time. You know, they've seemed to have lived in harmony. Is this really the first time this has come up?
This is the first time that this peculiar set of circumstances has arisen, where a local retirement system is using or is misusing its authority under 32D to aggressively remove an employee from a member in service.
So your attempt at harmonizing 32D with 31A is that a board has great degree of discretion in determining when somebody becomes a member, but once they become a member, they no longer have any discretion in the absence of removal or some of the other things.
Exactly, Your Honor, that they have broad discretion so that they could set an hourly threshold or a permanency threshold, but anything that is more than initial admission into membership is outside of their jurisdiction.
And the 9-week period satisfied that criteria.
Here they set a very low threshold, Your Honor, and that is ultimately the key to the case, that to become a member in service at the time, Ms. DeFelice had to work for a period of 30 hours for 7 days. There's no dispute that she did that. As
Then
soon as
she becomes a member in service and she's...
Yes, so they set a very low threshold under 32D, and they're bound by the consequences of that.
And I take it, if I understand this correctly, that you say, if we didn't interpret it that way, Section 3.3 let's say she hadn't, the way you read 3.3, right, she could, since she did unquestionably work more than 7 days for 30 hours, she could today buy back everything because she did qualify for that. Is that right?
As long as she hadn't separated from the
Yes,
service. So
right.
assuming, and at the time, there's no dispute that she was a member or hadn't separated from the service of Stoneham. I don't know if that's the case
So
now.
you would say if we accept Stoneham's interpretation of these 2 statutes, we run into trouble because it's inconsistent with 3.3.
It's inconsistent with 3.3. If you look at the other provisions in 3.3 as well, both the title of 3.2 and then the surrounding provisions in 3.2, especially B, C, and F, all of those also concern decisions relating to initial eligibility. You have late admission, you have post-age 60 admission. All of these things concern initial eligibility and initial determination of membership.
Okay, thank you.
Thank you.
Good morning, Mr. Gibson. You still get your full 7.5, even though we rest Mr. Martland. He gets overtime for the
Thank you, Your Honor.
extra. Make sure he gets appropriate compensation for the extra minute and a half that he.
Thank you, Your Honor. And may it please the court, Thomas Gibson on behalf of Christine DeFelice. So the statute does indicate that once you establish membership in the public employee retirement system, that membership is designed to continue until it's terminated by one of several events that are enumerated in 1A small I. The reason for that is because the membership rights of an employee are really, as this court has recognized just recently in the Perrick versus Betancourt case, 474 Mass 60, that it's a property right that they have that's current and not contingent upon satisfying any further conditions. So to allow an employee membership in the retirement system and then to say that that membership is going to be contingent upon your maintaining certain hours of employment really extinguishes that employee's property rights in that retirement allowance. So we would suggest, Your Honor, that CRAB in this case, and it has been a long-standing statute, and it has been a long-standing application of the law, and CRAB got it right in their interpretation of the statute, and not only CRAB, but the Division of Administrative Law Appeals and even Perrick before that have consistently held that Mrs. DeFelice was entitled to membership under the relatively low threshold requirement of the Stoneham Retirement Board. Now, the local retirement board is free to make any type of rules that it deems necessary to establish that membership. But once that membership is established, there are only specific statutory ways that that membership can be extinguished. And a reduction in hours, whether voluntary or involuntary, does not serve to extinguish that employee's rights in the retirement allowance. Nothing in Chapter 32, which is, by the way, a creature of the legislature entirely, authorizes a retirement board to throw someone out of a retirement system merely because their hours have been reduced. What the law does require, as Justice Gantz noted earlier, and my brother noted earlier, there would be a proration of retirement benefits that would be recognizing the limited hours of employment and limited credible service or proportional credible service of an employee.
But you get the
Did
health
Judge
care.
Ullman understand that? I'm sorry. Did Judge Ullman understand that? Because I noticed in his opinion, he was very much concerned about the financial impact that Crab's reading would have on local retirement boards.
Yes.
Did he understand this proportionality idea?
I would suggest, Your Honor, that the judge did not grasp that area, and among many things the judge didn't grasp, Judge Ullman made continuous reference to Christine DeFelice not being eligible initially for membership because she wasn't a full-time employee.
Yeah, that was just wrong.
That's just
because-
wrong.
Yeah.
But that is a policy consideration that CRAB rightfully noted is up to the legislature to address. Granted, this statute has been around for over 70 years. It's constantly evolving, Chapter 32. It's constantly being refined through administrative decisions and through judicial decisions. And it may well be time to examine it. Now, the legislature has, in the past several years, taken several stabs at reforming the public pension law.
This, the vote, if you work less than whatever it is, right? That was a new addition.
Well, in Chapter 21 of the Act of 2009, the legislature said if your compensation less than $5,000 a year, which if your hours were really reduced, you would no longer get credible service. So that was a change that they made to the benefit scheme. That didn't affect the membership rights, however. Those people who would
if
make
you're-
less
if
than
you're-
$5,000 are still members of the retirement system. They weren't thrown out of the system.
So Mrs. DeFelice, when she retired, she isn't retired, right?
She was not retired, Your Honor.
So when she is retired, though, she will have proportionate retirement benefits, but she will get full health care. Is that correct?
Assuming she vests in the retirement system and qualifies for
Oh, and
retirement
that would,
benefits.
so that's where the proportional comes in about vesting. Is that right? Or is it just
No,
plain
vesting-
years? It's just plain years of service and age?
You would vest with 10 years of service, Your Honor, in the retirement system and be eligible to retire under a combination of
Well,
age
she's
and
got
years of service.
she's got the 10 years.
She does not have a 10 years, Your Honor.
She doesn't? I thought she started, I thought this happened in 2001.
It did, but her employment did not continue with the Stoneham schools, unfortunately. So,
So the 10-year vesting, if you work 10 hours a week, it's still 10 years, even
Yes.
if it's not 40 years?
you still vest, Your Honor, in the
So the
retirement
vesting, the
system.
vesting is not proportional, but the creditable service,
And the benefits you would obtain at the end of your career would be prorated. With respect to health insurance, Your Honor, the Chapter 32 makes no reference to health insurance whatsoever. The Retirement Board has no authority to oversee or administer health insurance benefits for members of the retirement system. That's solely the responsibility of the retiring governmental unit to provide those health insurance benefits for an employee. Now, as a practical matter, health insurance benefits would be available depending on the plan that the employer has adopted.
If she vests or or it doesn't matter?
If she's a retiree, for example, the Group Insurance Commission provides retirement benefits to retirees.
Whether or not they're members of the retirement system, is that
No,
what
you have to be you have to be receiving a check from the retirement system in order to qualify for health insurance benefits under the GIC. Now, municipalities can adopt other retirement plans other than the GIC, obviously, and they have the authority under the Seoc versus Ludlow case to design their plan any way they want, as long as it complies with the provisions of Chapter 32B. So there's not the issue before the court in this particular case.
I was just trying to play out what the implications were.
So when the legislature changed the benefit scheme, or reformed it back in Chapter 176 of the Acts of 2011, they changed the years of service that you would require. They changed the benefits, how many years you have to work. They raised the normal age. They made those changes effective for employees coming into the system after April 2nd, 2012. So the legislature has always recognized that when that contract is formed with the employee in a Section 25(5), that and material expectations for pension are generated, those rights are to be respected and not terminated. What Stoneham would do in this particular case is allow someone into the retirement system, and then after on some arbitrary number of hours of employment would terminate those retirement rights. So we would submit that Crabb's decision in this case is correct. We would ask that the court reinstate that decision and reject the Superior Court's decision otherwise.
Okay, thank you.
Thank you.
Mr. Sacco, good morning.
Good morning, Mr. Chief Justice. May it please the court, Michael Sacco here on behalf of the Stoneham Retirement Board. Your Honors, the issue in this case is whether or not the full jurisdiction, that's the language that the legislature used, full jurisdiction, does it extend simply to initial membership eligibility? And we would suggest that it does not.
Don't you have to read the two sections together?
Which two sections, Your Honor?
The one that,
31A1 and 32D?
yes?
I think you need to read them in harmony, but not together. And if I'm trying to thread that needle for you, the way the statute is set up is...
So harmonize them for us then.
Yes. The way that the Section 3 is set up is in Section 1, it talks about membership and breaks it down into member in service and then member in active. It then goes on to Section 3.2, where it clearly gives a retirement board full jurisdiction, exclusive jurisdiction to decide membership eligibility. There's nothing in the statute to suggest that eligibility was simply an initial determination to be made by a retirement board.
So the retirement board, on your theory, can change its mind as you go along?
Absolutely.
Oh, I see. So somebody doesn't really have any kind of rights that are recognized as...
No, Your Honor, they have...
You may be eligible and recognized as a member, but the retirement board can then later take that away?
The retirement board has the right not to take away the rights that you've accrued.
What does that mean? I don't understand what the retirement board was doing when saying that you have eligibility for the 9-week period to be a member of the retirement system, but not a continuing eligible. I don't understand what they were doing.
Well, when they made the decision, well after this 9-week period took place,
Nothing wrong with that.
nothing wrong with that, that it made a determination that to be eligible to be a member of the system and accrue benefits that go with that membership, you needed to continue to maintain the amount of hours that allowed you into the system to begin with.
But the eligibility requirements at the time to become a member in the system was 7 days,
Right.
30 hours.
30 hours for 7 days allows you to become a member.
So she more than did that.
She did that, right. For 9 weeks, she satisfied that requirement. And then when that school year ended, she reverted back to her 19-and-a-half-hour
So as a
position.
practical matter, what is the impact, as far as you're concerned, of the recognition that she had membership for 9 weeks?
Well, the impact from our perspective is we were required to give her those 9 weeks.
And yes, but what does it mean as a practical matter for
Doesn't
her?
mean,
Nothing.
those 9 weeks,
Nothing.
those 9 weeks in and of themselves mean nothing, correct. Unless, in fact, membership of a retirement system doesn't mean anything unless you vest, unless you accrue enough creditable service.
What, she qualified, as the board found. So just explain to me how 3-3 would work. Couldn't she buy back her, isn't that the case?
Well-
If she can show she qualified for the requisite amount of time, can't she buy back between then and now, under 3-3?
No, Your Honor. What could have taken place, and because we had to do this looking in hindsight into what should have happened back in 2000 and 2001, had Ms. DeFelice come forward at the end of that school year in that 9-week period and asked to become a member, she, in theory, would have and should have been allowed a member. At that point, she could have bought back her prior service. 3-3 deals with late entry into membership in the context of someone who had a right to become a member or should have become a member and didn't, if there was an error.
Well, why wouldn't that refer to her?
Well,
Because,
it could refer to her going backwards, but not going forward, Your Honor. I think that's the distinction.
why?
Because establishing membership eligibility, in the board's view, and I think in the legislature's view, is a continuing eligibility process. You need to continue to maintain the amount of hours that allowed you into the system.
That's not apparent in the statute, correct?
Well, I think that, Your Honor, the legislature has given the retirement boards discretion in Chapter 32 in only 2 areas. This is one of them, and the other area has to do with the waiver of debts in Section 25(2), which I cited, which the appellate courts had said that when a retirement board has discretion, CRAB really doesn't even have jurisdiction to question that unless they've abused their authority. Here,
Isn't the discretion that's inherent in the retirement board to set eligibility requirements, which were met in this case?
to set them and to continue to apply them, Your Honor. There's nothing to suggest that once someone has become a member, that they are forever to continue as a member if they fall below the criteria.
Then,
But what do you do with 311, which says, in any event, the status of a member in service shall continue as such until his death or until his prior separation from the service becomes effective by reason of his retirement, resignation, failure of reelection, or reappointment, removal, or discharge from his office or position. Are you saying that is undone by 32D?
2 answers to that, Your Honor. I believe 32D is the more specific statute
Pretty
section.
specific.
Well,
In any event?
well, and then my second point to that would be that Ms. DeFelice was removed from the position that made her eligible. This court, in the Retirement Board of Attleboro case, determined that the word removal meant demotion, meant something less than a termination of employment. Otherwise, the legislature would not have used the words removal and discharge.
But if she's filling in for somebody, I forget exactly the facts, but she was filling in for somebody, wasn't she?
Right, I believe it was a maternity leave at the end of a school year. She was asked to pick up some additional hours, which put her over the 30-hour
I mean,
threshold.
removal usually has a somewhat pejorative sense that you've been kicked out of your position.
Not necessarily, Your Honor. A demotion can be due to lack of funds. It can be due to many reasons. It doesn't necessarily mean
But
that
what
it...
if you're just substituting? I mean, I'm just having trouble seeing that as a removal. She's doing this for some period of time because somebody's on maternity leave. The person comes back from maternity leave, and she's no longer doing the extra stuff.
Right. She's removed from that position that she was given. And respectfully, Your Honor, when you say you're having a hard time understanding it, that's what this court said in the Attleboro case. It said
Circumstances than here.
it said a demotion was a removal and that we have to give removal different context than a discharge. So, but I still respectfully, I think that the legislature has given retirement board full jurisdiction to determine eligibility.
Can I ask you a question, because I'm confused too? You're interpreting the authority to determine eligibility as being consistent with the authority that's in 3.2D. I mean, we would have to smush the two statutes in order to accept your position that determining eligibility means that you can do that at any time when get the letters mixed up, 31A1 seems to describe a very discrete set of circumstances under which somebody can be separated from service. But you're saying you can do that for other reasons under your authority to determine eligibility. How does that make sense?
Well, I think it makes sense. First of all, Your Honor, if I can just add one thing to that, and that is 31A1 has been interpreted, wasn't briefed, 11 times by this court and the appeals court. Essentially, how the appellate courts have viewed that section is simply to say that you don't lose your status, you don't lose your rights because of some change in status, the rights that you've accrued to that point. Membership is...
That's not what it says. It says what the expression is, once a member, always a member, unless. That's what it says.
Well, the once a member, always a member is a nice jingle that I think has been employed, but again, there is a financial impact because of this issue.
Yeah,
and
but that's beside the point. I mean, that's for the legislature to figure out, right?
Well, it is, and I think the legislature has also given the retirement systems the ability to determine part-time employees to be members of the system and what the circumstances and terms and conditions are.
Initially, but, you know, once the board determines that she's a member, doesn't that put limitations and restrictions on how the board can treat the employee after that fact? I mean, the employee has certain protections.
The employee does have certain protections, but that's not to suggest that those benefits or rights can't be modified in some way by some future action. This court recognized that in, again, it's not briefed, but since you're asking the question, the Madden versus Contributory Retirement Appeal Board case, which was a case in which the Teachers Retirement Board changed its creditable service regulation midstream that affected Ms. Madden, and this court said that the board was allowed to reduce her creditable service going forward because her status changed after the regulation was put in place. So
But she was still a member though, right?
she was still a member, but...
Okay, so that's different.
Okay, so with membership, a retirement system could have a regulation that says part-time members are not allowed to be members in the system. They could do that.
They didn't.
No, they didn't. They created an initial threshold
Well,
to
that's
get
not
into the
so-
system.
So what does it benefit you to get into the system initially, on your theory?
I'm sorry, I'm not sure.
On your theory that somehow this has meaning to say that somebody meets that threshold, 30 hours a week for 7 days,
Right,
and so somebody is then determined to be a member.
right.
But not really, because if you don't continue to do 30 hours a week, you're not really a member going forward. I don't understand that.
Well, you remember for the period that you satisfy the criteria, Your Honor.
9 weeks, you're a member. And what is the impact on you as an employee? I mean, what rights do you accrue As such.
In that 9-week period, if Ms. DeFelice had fallen down and been injured in the performance of her duties, she would have been entitled to an accidental disability retirement for the rest of her life.
And that's it.
Well, that's all that would be, that's probably the only benefit that potentially could have accrued during that time. I cited in my brief, we went off a little bit about the healthcare, the Shea case, which was a case in which dealt with health insurance, and it was a case where municipalities are required to offer health insurance for employees who work 20 hours or more, but when they fall below 20 hours, the way the statute is written, they don't have to offer it to them anymore. And the court upheld that as being within the purview of the municipality to not continue to extend health insurance. They could.
But that's because the statute allowed them to do it, wasn't it?
Well, yes. And I would suggest to you the
And what we're
statute.
talking about is, what does the statute allow you to do here?
Well, and again, I guess it comes down to, Your Honor, what you interpret full jurisdiction to mean.
Well,
but
let me
it-
ask you about that, because the appellants say that, that Crabb and Ms. DeFelice take the position that it's only initial membership. So 3232D, you say that that empowers the local retirement board to be able to address eligibility throughout the period of employment. You heard their reason for their interpretation of the statute. What's your reason for your interpretation of the statute?
Well, what I heard from my brothers is that it can't be that way. I didn't hear any rationale or legal rationale as to why it shouldn't be, other than this reference to 31A1, which talks about a member in service shall continue. But member in service status, just like someone who's regularly employed, does not mean that person meets the criteria for membership in the system. The retirement board has been given this, again, I keep going back to the full jurisdiction, has been given this sole authority, so much that it's not subject to PERAC review. It's not, you don't even need a regulation.
Reviewable discretion, is that what you're saying?
It's, yes, Your Honor, it's not reviewable.
But
So-
isn't
so-
the point that that the board made the threshold so low that now you're trying to avoid having to stick to it?
Well, you mean the subsequent change, Your Honor?
Well, the threshold, the 30
30
hours
hours,
for
right.
7
Now,
days.
well, the threshold is now changed to 20 hours per
Right,
week.
but we're talking about
Right.
the 30 hours. So.
But it's
Right.
still 7 days?
No, it's now consistent with many retirement systems, permanently employed 20 hours or more per week, which never would have allowed Ms. DeFelice to be in the system.
But if you're right in your theory as to what the board can do, if you had a teacher who had worked full-time for 8 years and then had a child and decided to go part-time, in your view, her going part-time below 20 hours would mean that she's been removed from her position and would no longer be a member.
I would say that her status had changed, and that, yes, she no longer, the removal is only relevant, Your Honor, if 31A1 applies. But we would say under 32D that once you don't meet the threshold or fail to satisfy, yes, you would fall below, and then, assuming she returns from her maternity leave to full-time, she then can buy back that prior service that she wasn't a member, and that would be prorated based on her
But
hours.
she would get no credit for the part-time that she did for the period in which she was going part-time to care for a child.
Not while she's working it, but she would be able to buy it back. I also want to stress, Your Honor,
I'm sorry, buy it back by the earlier period back.
Correct. Buy back the time that she wasn't a member. I also want to stress that what Stoneham is position here is not one that, if you agree with it, will necessarily impact every retirement board in the state. If a retirement board makes a decision that they want to follow the once a member, always a member, if they want to continue to extend benefits to someone who falls below the threshold, they can do that. What I'm suggesting is the legislature has said we have the discretion, Stoneham has the discretion to set a criteria, apply it consistently to require someone to be a member, and if they fall below that criteria, then that person no longer is a member of the system accruing benefits.
Okay, thank you.
Thank you, Your Honor.